So welcome everybody. My name is Marty Mascari. I am a contractor under the North Central Texas Area Agency on Aging and North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. We are thrilled that you're joining us today. Thank you so much. But we are also thrilled to have our partners at Haiman+Barnett here to talk to us today about the truth about wills, trusts, and estate planning. Namely, Susan Barnett's going to be giving us the presentation. But before we get started, we're going to talk a little bit about CEUs, which is the next slide. If we could advance one, please. And then we'll talk about CEUs. For those of you that are joining us today for CEUs, we're providing complimentary CEUs for licensed social workers and licensed professional counselors in the state of Texas. If you have a different license in Texas or a license outside of Texas, you're more than welcome to go through the process and get a certificate and submit it to your jurisdiction. But please note, there's no guarantee that we have that they'll take it. I will tell you, I've had people from out of state. Most recently, I think I had someone from Ohio that told me they were able to use our certificates. I've also been contacted by jurisdictions before asking for more information about a presentation, a webinar we've done, in order for them to decide if it met their threshold in regards to what they expect for their CEU education. I invite you to just go through the process, get a certificate, and submit it, but please note there's no guarantee. We're also providing certificates of attendance for anybody who would like one. Today's webinar is worth 1.5 hours of CE credits. You must complete the entire live webinar and the Q&A. Excuse me, I'm so sorry. I am very sorry. In order to qualify, you must also complete the Google evaluation survey form at the end of the presentation today. It should pop up when you close out of Zoom today. It should ask you if you would like to take the short survey, but I realize some of you work for companies that have pop-up blockers and that sort. You will also get that link in a follow-up email that will go out tomorrow, and then you will have a week from tomorrow in order to complete that survey, and then give us about 4 weeks after that to get the certificates out to you. We were caught up, and right now I'm running behind, so I know I'm a little bit behind on getting those certificates out to you, and I certainly apologize. I've got lots of stuff going on personally that's got me going. But we will get those certificates out to you. Thank you so much, and I'm going to turn it over to Sheila Williamson to introduce Susan for us.
Good morning, everyone. I am so happy to be here today with you. I'm sorry about the technical difficulties, but you know what? As I have certainly learned more than most of you this week, technology is not my friend. It really is not. We need it, but to say that we're friends, that is a complete lie. No, but I am learning. You can teach an old dog new tricks. It just takes longer for some of us. So bear with me there. I am so proud to introduce my boss, Susan Barnett, to talk to you and teach you about wills, trust, and estate planning in general. Because these, generally speaking, this particular program here is 90% of the questions we get. I'll be honest with you. It really is. So this is going to answer so many of the questions that you have. And speaking of that, you know our policy. Please put your questions in the Q&A, not in the chat. I will monitor the Q&A during the presentation, and at the end, I promise you that we will answer your questions, okay? That way, because it's hard for me to go back and forth to all these things, but while this is going on, but I will be happy to do that and then let Susan answer them. Because as we've talked about this before, I am not a lawyer and cannot legally answer any of your questions. No matter how many times I say that, people seem to still think that I am, and I cannot. So anyway, she has so much experience. She's a wealth of knowledge, but she's also very personable, and all of our families just love her. So without any further ado, here's my boss and your new friend, Susan Barnett.
Hi, everybody. Glad to be here this morning. I want to just give you guys a good overview of estate planning, basically. Something that might apply to you personally, applies to everybody, but also will be good knowledge for you to have in dealing with patients, clients, and the like. And so hopefully this education will open your eyes to some things that you can share with others and make a difference. So we'll go ahead and get started. Sheila, if you will give me about 10 till 11, a warning, just so that, because I may or may not be looking at the clock as I go.
Done.
Okay. All right. So what is an estate plan? People get hung up just on the word estate. Oh, I don't have an estate. I just have a house and a checking account. Well, that is an estate. There's no minimum for thinking about what an estate is. And an estate plan looks at your financial needs and your assets and your family circumstances to make sure that what you have works while you're alive. And then also works for your heirs or your beneficiaries the way you want it to. And so that's really, estate planning doesn't just encompass where your stuff goes when you die. It also applies to what you have in place that helps while you're alive. There are lots of planning options, and we see them. They come in all shapes and sizes. You can just spend every last dollar you have, and then you don't have to worry about that part of it as far as where it goes when you die. But that's a little bit hard to plan since most people don't actually know the date of their demise. You can die without a plan. That's called intestate. So without any kind of a plan, there is a plan because the state of Texas has a plan, and there's a good chance you wouldn't like it. And if you're in a blended family, it's almost guaranteed you wouldn't like it. And so that's not a good plan. You can put everything in joint names with right of survivorship. And then that can help as long as everything goes as planned. You can create a will. You can create a bare bones estate plan that doesn't do anything but deal with where your stuff goes when you die. Or you can create a living trust plan that will encompass all the things that we are concerned with when we are talking about estate planning. Every year, there are millions of civil lawsuits and bankruptcy petitions that are filed in the United States. And that's one of those things that people get concerned with. Over 50% of marriages sadly end in divorce. When we talk with our clients about things to be prepared for, the most common tragedy that anybody goes through is a divorce, and it does impact and can impact estate planning. Most Americans don't have a plan. A majority of them don't. And it may be because of procrastination. It may be just lack of knowledge. So we're going to try and address those things here today so that you guys are going to be in the know and you'll be able to share that with others. What we find are 5 major concerns that people have. First one being the governments and the courts being involved in your life. Most people would like to act independent of those entities as much as possible. And so that is one of the first concerns that people will share with us. Along those same lines, not wanting to pay unnecessary taxes or fees. A big concern people have is going broke from nursing home and medical expenses. And there are ways to plan so that that does not happen to you. And then there's the concern about scams, and we call those predators, and then creditors may be legitimate, but also can be a problem that people want to be protected from or have their family protected from. And then finally, what about how your family is going to act if you become incapacitated or when you pass? Are you going to have a plan that creates fights, just doesn't answer enough questions to calm that down? Or will you have a plan that brings people closer together? I will say on this one, because I do the trust administration and the probate in our office, I've seen lots of different scenarios, and sadly I've seen cases where families don't get along. We can do all the planning in the world to try and help reduce the stress on the family. However, we cannot change personalities. And so I want to be really clear about that. If you've got somebody in your family that's difficult to deal with, they're probably not going to magically become easy to deal with when you die and we've got money involved. And so we do what we can in our documents and the things that we do. The estate planning can work in a way that that answers a lot of questions and reduces stress, but it can't take care of those personality conflicts that might come up. The number one reason people don't plan is because they do procrastinate. We have a lot of young families that if something tragic happened and they didn't have a plan, it would be disastrous, but they just don't get around to getting it done. And I'm grateful to say that most of my all of my clients so far have outlived any of those really tragic situations with young children being left behind. And so I'm grateful for that, but it can happen. And we've all known situations where that happens. The other thing is you don't know what you don't know. And so hopefully today will help with that, because we'll give you some working knowledge to be able to educate yourself and educate others around you and point them in the right direction. Today's not meant to answer any specific legal questions. We're not giving legal advice to any of you or to you for your clients, but just the knowledge to be able to know what direction to go. Now, there's different ways that estate planning is handled. The traditional way is you've got a financial advisor, you've got a CPA, you might have an insurance person, and then you've got your attorney, and everybody does their own thing and hopes that it all comes together in the end. An integrated model is how we operate. We don't have any of those people in-house. We are our own separate entity from any of those. But we love working as a team with families and their other professional advisors so that we make sure that what we're doing it dovetails with the other professionals that are giving our clients advice. So that is an important piece to look for when you're looking at estate planning. There's a lot of reasons that plans fail. And we've got 7 here that are very common. Poor documents or no documents at all is probably the number one issue. But we also have clients that don't keep their plans current, and that can be a problem. There are things that change in people's lives and they don't update their plan to flex with those changes. And that can create some issues. There's changes in the law over time. And so what I like to tell my clients is every 3 to 5 years, take a look at your plan and see, is it still doing what you want it to do? If that means that you need to sit down with your attorney and go over it, then do that. But make sure that over time you keep it current. A big issue can be when you are not from Texas and you move into Texas and your documents don't get updated to Texas documents. Every state has their own way of doing things. Now, I will tell you that a living trust crosses state lines easier than any other estate planning documents, but it still needs to be reviewed. And so that's another reason that things can get a little hinky is if we're dealing with out-of-state documents when someone is incapacitated or passes away. Not having long-term care provisions can be a problem at times. One problem that I run into a lot is the assets not being properly aligned with the plan. If you've got a living trust, you'll hear the word funded sometimes. The assets that are owned need to be appropriately aligned or funded into that trust. If they're not, then there's a missing element there that's going to cause some extra work and extra expense. Not having protection for remarriage. If we've got a couple and they get married and one spouse dies and then they've got a plan together, but then without making any adjustments, the surviving spouse gets remarried, there can be some issues there. And then not creating protection from creditors and predators for that surviving spouse or for the eventual beneficiaries. So do-it-yourself plans, there's a lot of them out there. The most common do-it-yourself plan is to do things like put your kids on your accounts and make sure you've got everything lined up with beneficiaries, and all of that is in the effort to avoid guardianship and probate, but doesn't always work. But it is definitely the most common do-it-yourself plan I see before we get to do the planning for people. But then there's all these internet plans, and I'm not going to spend a lot of time on these slides. You guys have access to these, but it's just as an example, some of these things that are a little bit shocking when you find out about it. Those internet sites where you can go download documents and create your own, they are not practicing law. So they are not held to the standards that lawyers are held to make sure that the documents are correct. And if you realize when you get to the end, I had a lady come in and bring up her boxed plan to me that she said, I got all the way through this. I paid for it. I got all the way through it. And at the very end, it says, this is not legal advice. It's recommended that you seek the advice of an attorney. And she was very frustrated with that, but she was smart enough to say, well, I don't need to do this then. I need to get an attorney to actually help me with this. But she wasted her money on something that really wasn't going to help her. And so they will have these disclaimers. You see this one from LegalZoom. We're not a law firm or a substitute for an attorney or a law firm. I mean, that should tell you right there. And so what's wrong with that is that you end up with situations where you've got documents that don't actually get you what you need, or they're not going to work when you need them. And when you find out they're not working, it's too late. So we're going to walk through and talk about some of the documents that are critical for everybody to have. There's living documents that need to be in place while you're alive. And then there's death documents that you need to make sure you have upon your death. And so when we talk about just the living documents, we're talking about the financial document, the statutory durable power of attorney. And then we've got healthcare or living healthcare documents that are living documents. We've got medical powers of attorney, directive to physicians, which is also considered a living will. Now you hear that phrase or that term a lot. And then it's good to have a HIPAA release form and declaration of guardian in case you are incapacitated, where you can tell a court who you would want to be your guardian. And sometimes, even more importantly, in that document, you can say who you would not want. And sometimes that's really important because there may be someone you don't trust that might try and step in and take over your life. And being able to tell, through this document, tell a court that that is not somebody you would ever want is very powerful. And then we've got our death documents, which we have somebody who's designated to dispose of our remains, we have an anatomical gift form, and we have a will. Now, what's interesting is how the living trust comes in. All of these documents that are on this slide would be included in a trust plan. If you're getting it from a lawyer that knows what they're doing, you're still going to need all of these documents. But some of them are really just safety nets. For instance, the statutory durable power of attorney is a very powerful document if it works, but whether it works or not depends on who you're dealing with. And so a lot of people think, well, I don't need to worry about incapacity, because if I'm incapacitated, my child has my statutory durable power of attorney and they can go take care of anything they need to. Well, that is what that document is intended for. But let's say mom becomes incapacitated. She's bedridden. Is not in her right mind anymore. And it's time for her daughter to go and start paying her bills and taking care of things. And so she goes to the bank and she says, here's my power of attorney. And I want to get on mom's account as power of attorney, and so that I can pay her bills and take care of her. A very typical response from a bank is, we will be glad to honor that power of attorney, but you need to bring your mom in to tell us that it's okay. That's a very big moment of frustration for the daughter, because she's trying to do what's right for mom, and now she's stuck because mom can't come to the bank. Mom is not in her right mind to be able to tell them that it's okay. Who knows what mom might say? If she's, got Alzheimer's and she's angry at her daughter for taking over her life, she may say, no, I don't want her to be handling my affairs, but she's not got the capacity to make that decision. And so now the daughter is stuck. And her only option at that point to be able to take care of mom is to file for or apply for guardianship of her mom. And that is not something that anybody wants to go through. We'll talk about that a little bit more in a few minutes. So while that document is there and we all know what it's for, it's not usable. And before you get too angry with the banks, there's a really good reason for their answer. If they guess wrong and mom has revoked that POA, or mom is no longer alive, that POA is no longer valid. But they have no way of knowing that unless mom shows up and tells them it's okay. And so they have the right to refuse to deal with that agent under that POA. And if they do guess wrong and that daughter is there to steal mom's money, they're liable for the decision they made. On the flip side, if she walks in with a certificate of trust and says, here's my affidavit that says I'm the new trustee on this case, they are not liable and they cannot refuse to work with her. And so that's a critical distinction between a will plan that just has a power of attorney and a trust plan that has trustees representing as fiduciary agents. And so all of these documents are critical, but that's an example of one that is a safety net that we still include when we do a trust plan. But we hope it's never needed because we've got a trustee that is acting and managing the assets. And the same is true for the will. We always include a will in these packages. I had a case once where the trust came to me and we needed to administer the trust, but they had not funded the trust. None of the assets were in the trust. And the attorney that did the trust did not do a will because he said, oh, you don't need a will if you've got a trust. Well, that is not true. If no one can fully fund that trust except the client, and if the client doesn't do that, that will is needed. It's a pour over will. It says put everything in the trust and then the trust takes over, but it doesn't avoid probate if it's needed. But if you don't have a will, now we've got an intestate situation. That case was very difficult because we had a blended family. We had stepkids that wanted to do the right thing, but making that happen and helping their stepdad was a problem. And so we always include a will in a trust plan, because you never know, even if the family is very diligent and they get everything in the trust before they die, there might be something that they inherit that they don't think about, later. Oh gosh, I need to get that in my trust. I mean, there's all kinds of things that can happen. And so that will is another safety net document that we make sure is in all of our plans. And any good lawyer would make sure there's a will included in that plan. Trusts come in all shapes and sizes. And they can be very, very basic. They can be very, very complex. You've got testamentary trusts that are included in very complex wills. I don't recommend those, because if you're going to set up a trust, why not set up a living trust that's already operating while you're alive, that you've already got the assets in and all of that. If it's a testamentary trust that's in the will has to be probated to get to it. And then someone, not you, has to set that trust up and get the assets in it, which is a lot more difficult than you doing it for yourself. There are most of the trusts that we do or see are revocable trusts while the principals are alive. And they're amendable and changeable. They're not set in stone. And so that's what most of your trusts are going to be. But then there's also irrevocable trust, and they have their place as well. There's certain kinds of planning that need that irrevocable trust to be a part of it. We do some things called heritage trusts for your beneficiaries. There's tax planning trusts and asset protection trusts. There's retirement planning trusts, and there's Medicaid planning trusts. So, and probably many, many more. These are the ones that we see most commonly in our practice. So when you've got a living trust, that's created by the trust maker while he or she is alive. The testamentary trust is created through the will, and so it doesn't get established until after the trust maker has died. And then there's the revocable trust that can be modified and amended and restated and terminated. And then there's the irrevocable trust that cannot have those things happen to it. It's set in stone. And so those are the four main types of trusts. And you can have a living trust that is revocable or irrevocable. Testamentary trusts are generally going to be irrevocable because they come after death. A good plan will have special instructions for incapacity, and that avoids guardianship. If you've probably, with some of you in the line of work you're in, you've dealt a lot with guardianship. Some of you may have personally dealt with guardianships of someone you cared about. But anybody that has dealt with guardianship knows it's just an awful thing to go through. It means taking someone you love into court and having them declared formally incapacitated. It means that they not only have had to go through a specific medical exam to determine their cognitive abilities, but it also involves two attorneys. You've got the attorney that represents the applicant who wants to become guardian, and then the court has to by state law appoint an attorney to represent the proposed ward, just to make sure that they're not being taken advantage of. And so you've got two attorneys that are involved at the minimum. It does not happen quickly. So if you've got a situation that needs to happen, we need to get control out of the hands of the person who owns the property quickly because they're wasting it or they're being scammed, then you've got delays there. And there is something called, used to be called emergency guardianship. Now it's got a different name, and it's not coming to me right off the bat, but it is more, it's got a quicker turnaround, but it's still, it takes a couple of weeks to get it done. And then it's called a temporary guardianship. It's a temporary thing until you can get the full guardianship in. These are things that most people don't want to be a part of. And so if you can avoid guardianship, avoiding guardianship is always a good thing. Avoiding probate is not as bad as guardianship, although you might hear horror stories. I'm told that in Texas, our probate system is actually easier than a lot of other states. And so we have it good here, but it's not a fun process. And some of it, you've got the expense of it. You have to have a lawyer. You can't do it without a lawyer. It does take time, and the assets that are in the decedent's name are frozen until that probate process is over. So if you're in the middle of selling your house and you die, your family is going to have to wait till probate is complete before they've got an executor who can step up and finish the sale of that house. And that can create some real issues. It also, and probably this is the thing that bothers people the most, is the public nature of probate. The probate courts are courts of public record, and they always have been. So this is not a new development. However, the new element that is included now is the internet. The last, 20, 30 years ago, you had to walk into the clerk's office, give a name, and ask for the file. And if you did that, they had to give it to you because it's public record. But you look at it and make copies and all those kind of things. But now that all that information is on the internet, that means anybody can access it anytime. And then they know things. They know things like who your executor is. They know who your beneficiaries are. When the probate is finished and there's some sort of an inventory, they may get to see all of your estate. And those are all things that we think of as private information. And now it's out on the internet for anybody to grab. They can use it for whatever purpose they want. And so what we find is that people that have to file a probate end up getting spam calls, and their cell phone number is not anywhere in those records, but it's easy to get to once you have a name. And so they'll get phone calls and text messages. Sometimes it's legitimate. Sometimes it's a realtor that's looking for, real estate that might need to go up for sale because it's going through probate. It's not how I would personally choose a realtor, but it is a legitimate way to try and get business. Sometimes it's a pure scam, and knowing the difference is very difficult. And we've got a grieving family that's having to deal with this on top of everything else. And so probate is just an unnecessary thing that your family would go through when there are ways to plan around it. And then if you've got any out-of-state property, I've got a case right now where the trust was actually done in Florida, and they've got property in Florida, but it's in the trust. And because it's in the trust, we're not going to have to go through a Florida probate. She lived here in Texas when she died, and we can do a Texas probate, and I'll reach out to a Florida attorney to make sure that we are taking care of any Florida laws we need to abide by with regard to that trust, but we're not having to go through a Florida probate. And so a trust can be really helpful in that way. And if you've got a Texas trust, but you own property out of state, that real estate can go in your Texas trust, and then you're never dealing with that other state's laws. So I've given you some information, but implementing it is critical. If you know these things, but you don't do anything about them, or your clients or your patients don't do anything about them, then it's absolutely worthless. So we've got something that we do. We create reports that are just informational reports. And you can see this in your PDF and go look at these later. If you've got a desire to learn about any of the subject matters here, you can email us and we'll be glad to send you those free reports at any time. Sheila's really good about answering those as well. So, and so I have gotten through that much quicker than I thought I would, but I think we're at a good spot to just take questions. We tend to run out of time with questions, so I'm not disappointed that we are through the slideshow part of this. So let's see what we got.
Yeah, we've got a lot of time. We've got 30, 40 minutes? 40 or 50 minutes. So we've got plenty of time.
Okay.
But do you want to, is Sheila there? Is Sheila
yes. Yes.
Yeah, she's there.
I'm going to let you take care of the Q&A. She does a really good, much better job than I do.
Oh, yeah. Okay, first question from Gilbert. He says, sorry, this is a personal question. What is the simple way to create a joint tenancy? First off, please explain what that is because people don't understand that.
Okay, so joint tenancy, the most common joint asset we see is like a checking account that's husband and wife joint tenants with right of survivorship. You can purchase an asset with someone else and create a joint tenancy. It depends on what kind of asset it is, but the reality is, while joint tenancy sounds like it could be a simple option, it actually is can create more problems if something happens to the other owner. And so when we with a living trust, you can title the assets, and that's how just to get a little bit more in depth on how that works. With a trust, first of all, you've got three main people that are part of this trust. It's the trust maker, the trustee who manages the assets, and then the beneficiary who has the benefit of the assets. In the beginning, on a typical living trust, our client is all three of those, or if it's a couple, they serve in all three of those roles together. So when that trust is their alter ego. It's not a separate entity. It uses their social security number, doesn't create any kind of a separate tax return or anything like that. It just gives a way to own the assets without having to go through guardianship or probate if something happens to one of those principals. And so, so your joint property, if it's in your joint trust, becomes easily accessible without any issues. If you rely on joint tenancy with right of survivorship, then let's say husband and wife have a checking account and they're running along and they have a car accident. Husband's killed, wife is surviving, but she is incapacitated. There is no one who can access their joint account without possibly a power of attorney might work, but as I discussed earlier, often doesn't on that bank account. And then somebody's going to step in and have to become her guardian. And so that would be true for any joint tenancy with right of survivorship. As long as everything goes normal, then it works. But we all know life is normal until it's not. And what that's going to look like is anybody's guess. And so if that joint account was in the living trust, titled in the living trust, it would list the husband and wife as trustees of that living trust, and they'd be the ones that had access. If that very same scenario happened, then whoever they had named in their trust document as their successor could step up into that role with the change of one document. Maybe not even need that, but probably in the case of incapacity, it would have to be made clear why they are stepping up, and they would need a new certificate of trust that shows that they're the current trustee. And then from that point, and that's not something that doesn't involve court, doesn't involve a great delay in time. They can get access fairly quickly. We don't look at joint tenancy very often because we know that things don't go the way we plan, and we can't predict what that out of the ordinary circumstance is going to be. So the trust can anticipate those things. The trust never dies. And so it leaves instructions. Even if you run out of trustees, it leaves instructions on how to get new trustees. So creating a joint tenancy is not always the best way to go, but it really is just ownership and making sure whatever that ownership document looks like, that it has the right language in it to be joint tenants. One thing that a lot of people are relying on these days, and I like to address this because it's kind of, it's out there, but it's not, is transfer on death deeds. Several years ago, it may have been as many as 10 years ago now, the state legislature decided that they wanted to try and make it easy on people so that they wouldn't have to go through probate. And they created something called a transfer on death deed, where you can, and that's like sort of a joint tenancy with right of survivorship. A couple can have a joint ownership, and then they can say who they're, and the surviving spouse would become the owner if something happened to one of them, and they can name a beneficiary to be an alternate if something happens to both of them. And that sounds great. But if you actually read the law, one of the things that says in there is that it does not pass with warranty. And if any of you've ever bought a home, you know that the title company, you're going to go to a title company and you're going to ask for title insurance. And if you don't have a clear history of warranty over the years with the title insurance company is going to look at you and say, yeah, we don't want to insure this title, because if someone comes along and claims they have a right to it, there may be a problem. And so that language right there in the statute makes it not a great idea. And title companies really don't like them. And so we've not used them. We don't like to use them. It's also, even though 10 years may seem like a long time, it's not enough time for them to really be tested through the courts and all the way up. And so we don't know how well they're going to work. So that's another thing that kind of people have grabbed onto because they've heard about it, but they don't, it doesn't do a great job for our clients, is what we've discovered. So,
Susan, can I ask you a quick question about that?
Sure.
I guess that's a statutory problem and not a problem that could be corrected by just having an attorney change wording in the document.
Correct. That's because it's in the statute that it says it does not come with warranty. There's not really anything we can do about that, and that's why the title companies don't like them.
I see. So the Ladybird deed, does that work better?
Ladybird deed is tried and true, and it is different. And I don't do a lot of them because I personally don't do Medicaid planning, and that's where the Ladybird deed comes in often, is with Medicaid planning. And there is specific planning that can be done if you are dealing with someone who is needing to be in a nursing home and they don't want to spend down everything they have to get qualified for Medicaid. There are ways to plan within the rules of Medicaid so that they can become financially qualified for Medicaid. We personally, in our firm, we don't do Medicaid planning, but there are a lot of lawyers out there that do. When we get a call on that, we will always refer to somebody that we know and trust. But the Ladybird deed really comes in handy when it comes to that Medicaid planning. And it is used often there, and it is very widely recognized.
Sure.
Okay, next question. What is an example of an anatomical gift?
So our anatomical gift forms, that's your organ donor form. A lot of people will choose to be an organ donor by saying something when they get their driver's license and getting that little heart on their driver's license. And that just tells first responders and hospitals that you are an organ donor, so that if there is a need for that, they know how to take care of you or your body. But an anatomical gift form actually goes into a lot greater detail. We have all kinds of choices on ours as far as the different things you're okay with donating, the different organs you're okay with donating, the different ways that you're willing to donate. Or if you're not willing to donate, you can say that on that form so that it's very clear that that's not something you want. But an anatomical gift is, I'm giving my organs for someone else who needs it, or for science, or for education. That kind of thing. So that's what an anatomical gift is.
Next question. Do you need both a will and a trust?
Yes. And that question may have come through before I answered it in the presentation, but I will mention it again. Yes, you need a will to back up that trust, because not everybody is good about getting their assets titled in their trust. One thing to note with trust, we don't list the assets that you own in your trust. If we did that and you got a new account or you got rid of an account, that would mean you'd have to change your trust. And we don't want people having to come back and do that. So the way that the trust takes ownership is by retitling. So when it comes to real estate, our firm drafts new deeds. And so we'll draft a deed that transfers it from you personally to your trust. But when it comes to things like bank accounts and brokerage accounts and life insurance policies and those kind of things, we give instructions, because if I called the bank and told them I needed them to change the name on your account, they better hang up on me, because I don't have that authority to do that. So we give you good instructions with regard to all the different kinds of assets. But you can imagine, as I mentioned earlier, some people just forget, don't get around to doing it. Or there's an item, just a particular item that is not in the trust when they die. And so that will is called a pour over will. And it literally says, okay, you're going to have to go to probate for this asset, these assets that are not in the trust. But once the will is probated, the executor their only job is to get everything moved over into the trust. Once they do that, then the trust takes over, and whatever specific terms you've put in the trust, then that's how it's going to go.
I would like to add onto that, if I could. The importance of when you put the house in a trust, getting the insurance changed over so it identifies it's in the name of the trust, and not just, we're dealing with that right at this minute, and we didn't even think about it. But fire and like homeowners insurance, all of that kind of thing.
Yeah. Yeah. So what you do is you call your insurance company and you tell them, we need our trust to be an additional insured. And then that way, if someone other than the trustees has to deal with insurance issues, you've got the ability to do it. And so, yes, you make the trust an additional insured, and then they will work with the trust and make checks out to the trust and those kind of things. Thank you, Marty.
Thank you.
Okay, next question. What happens if a will was done, but the executor is not executing it? How long does someone have to execute the will?
Well, the law says 4 years. But the beneficiaries and the other people involved shouldn't have to wait that long. Once you get past 4 years, it becomes more difficult to probate the will. If you've got an executor that is not doing their duty, then you need to get in touch with an attorney and demand that they file the will for probate. There are ways to do that, and you need a lawyer to make that happen, but you don't want to wait. I mean, I wouldn't, if they're not going to do anything within the first 6 months, and that's just a practical suggestion, I would start, looking into getting an attorney that could help with making that happen.
Next question. What is the price range for setting up a living trust? And is there a monthly fee to maintain or manage the trust?
So that's going to be dependent on who you call and hire. And we don't, is it okay if I talk about us for a minute, Marty?
Yes, as long as you just use it as an example.
Yeah. So our policy is we offer free consultations, so that we can sit down with you and assess your situation and make recommendations, and there's no obligation there. And so we do that so that we can really advise you well. That's not how everybody does it, but we don't even try to quote prices until we know what your circumstances are. You'd be surprised what people will come in and say, oh, I've got a really simple estate, and a lot of times people will think it's simple because they don't have any children. And that's one of those things that actually makes it more complicated. And so until we can sit down and educate a specific person on their situation and what they need. We really don't know what it's going to cost. And so that's why we offer a free consultation. We don't want you spending money until you know that you want to move forward. And so I know that's not a very satisfying answer, and I know it's one of the least favorite answers. It depends, but it really does depend. It depends on the attorney you talk to. It depends on what your particular financial and family situation is.
But you're going to be looking, wanting to be looking for an elder law attorney. Would that be correct, or a estate planning attorney?
It depends on it. I mean, estate planning for sure. You want to make sure. And what I'll tell you, I tell all of my clients, what I'll say at this point is, if you, after just what you've heard today, you go sit down and talk to an attorney and you feel like you know more than they do, don't hire them. If the education you've gotten today makes you more knowledgeable of trust and you would like to have a trust and they don't know anything about trust, or they tell you you just don't need one, then they're probably not the right fit for you if you think you would like to have a trust. So that's always I encourage my clients to shop around if they need to, if they want to compare prices or whatever, that's fine. But please don't hire somebody that doesn't know as much as you do after hearing this presentation today. And then elder law is a very loose term that encompasses a lot of things. But if you're needing to do Medicaid planning, which a lot of times that's what people are thinking of when they think of elder law, then you need to make sure you've got an attorney that does Medicaid planning. Like I said, we don't do that, but there are lots of attorneys out there that do them. If you've got an elderly person who needs a guardianship, only attorneys that are certified to do guardianship can do guardianship. And so there's specific things you need to be looking for depending on, what's happening.
Okay, next question. A family member who has not planned a will or trust, what happens to their assets, such as their house? How would a family member be able to take over payments or sell the house?
So if there is no plan and we've got incapacity, then a loved one's going to have to step in and apply for a guardianship. If there's no plan and we're talking about death, then there is a plan. And it's called intestate succession. The state of Texas has said if you have no plan, then this is where your assets are going. For some reason, a lot of people think that if they don't have a plan, their assets are going to go to the state. That is incorrect. If their assets go to the state, it's in unclaimed funds because not one single family member can be found. But the state doesn't get your assets to go put in their budget and include in their spending. So that doesn't happen. But if there's no plan and we've got family members out there, then an interested family member can go in and apply to become the administrator of the estate. And then that estate is going to go where the state law says it's going to go. And there are some very complex rules surrounding that. If you've got a family that all the kids are joint kids, and you've got, a husband and wife, what the law says with regard to that is kind of your typical, what a husband and wife will would say, everything to the spouse, for the most part. And then if the spouse is not alive, everything equally to the kids. There are some small exceptions in there to that. But where it gets really tricky is with blended families. And I can't see anybody's faces, so I won't see your expressions when I tell you this. But when I'm in a live in-person conference, this is the statement that gets more reaction than just about anything else I say. If you are part of a blended family and you have stepchildren and you do not have a plan and your spouse dies, you will own your home. Assuming it was community property, you will own your home with your stepkids, and there's not anything you can do about that. I had a client at one time, I had a friend come to me one time, and she said, my stepdad is in the hospital with heart issues. Do you think he needs a will? I'm like, oh my goodness, yes, he needs a will. Even a simple will. They'd been married for 40 years. Between the two of them, they had 9 children. He adopted 2 of her children. So legally he had 7 children. And 2 of them were So that was his, hers, and ours because he adopted 2 of her children. And then 2 of her children were older and he didn't adopt them. So very complex blended family, but they've been married for 40 years. And all of them saw that all of his kids saw his wife as their mom. I mean, they all loved each other. There's no bad blood there or anything. He didn't want to sign even a basic will that left everything to her because he thought if he signed the will, that would mean he was going to die. Not really a logical thought process because he died anyway, and he died without a plan. And she brought her mom in to me after he died to see what we could do to get things straightened out. She wanted to move to Louisiana and live with her sister. She was living in their paid for home here. And the reality was she owned that home with her 2 children and the other 5 of his kids. Now, there are ways to disclaim and gift and all kinds of things. It gets very complicated, but to add to this issue, 2 of those children, 2 of his children were special needs and didn't have guardians. But even if they had, the guardians would not have been able to sign away their right to that house. Now, they've been in that house for 40 years. She'd helped pay for it. And it was their community property, but half of it she had no right to, because when you die within that situation, all of your half of the community property goes to your children, not your spouse. And there's good reason for that when we're talking about a gold digger that's come along in the last year of life and you want to make sure they can't take the estate. But what about those blended families? And I run into them all the time. That I've got a client right now, a family that is just precious to me because there's 1 son from each previous marriage, and then they've got 2 children together. They were together for 30 or more years before he died. And that oldest son of his loves his stepmom. I mean, he calls her mom. He wants her to spend all the money. He doesn't want, and they had, thankfully, a good plan that did not create an issue. But even when it's a good family and everybody gets along, it's a mess if you don't have a plan. And so something can be done. Probate has to happen, but it is not an easy thing to clean up.
Okay. Next question. In order to go to probate, do you need an attorney or can you do it yourself?
The legislature, in their great wisdom, has decided that you have to have an attorney. And my only explanation for that is there's a lot of attorneys in Austin, or across our state serving in Austin. And so, I mean, it is a complex process, don't get me wrong. And it's advisable to have an attorney, but in specifically in probate cases, you absolutely have to have an attorney.
Okay. Next question. I have completed the directives forms through the Texas Department of Human Services, such as medical POA and financial POA. Are these directives okay?
I have not studied them. They're going to meet the statutory minimums of what's required by the law. And so that is okay. But customized forms would be much better. And I always try to remember to tell my clients after they've signed their documents, if you ever are offered in the hospital, hey, do you have any of these documents? First of all, the answer is yes. And don't ever sign the hospital's documents because there may be something in there that revokes what you've done. Now, those are only going to deal with the bare minimum. They're not going to, it's not going to be a will. It's not going to say where your stuff goes when you die. It's not going to give anybody great permission other than maybe there might be a statutory durable power of attorney in there, but we've already talked about the problems that can come with. So it's not something to rely on. May do just fine for your medical decisions, but probably not going to really be what you want for financial decisions.
For Angela's question, can I suggest that you would really probably want to seek out the advice of an attorney. It's when you get into that kind of specifics, you really want to have an attorney that can look at the whole picture and
Right.
other than just the information you've given. So I'm just going to advise that you just reach out to an attorney.
And
So,
Kay, I
Yeah.
don't understand this. I don't know which question she had earlier. So I don't understand that. She's gonna have to repeat it because I don't know what it was. The next,
Are we talking about Angela?
no, I'm talking about Kay Bell. She
Okay.
said
Oh, okay.
completing question earlier, what do I need to protect him? I don't know what she's talking about. So,
Okay.
next question. Now, this is a lot. My parents had a TOD, a POA.
Hold on, Sheila. That sounds pretty specific. I don't know if that's Angela or if that's
No,
somebody
it's
else.
anonymous.
If it's, oh, okay. Well, if it's a specific question, I really would recommend you call for a
Yeah.
consultation with us or somebody and sit down and talk
Yeah.
it through. I don't want to get into details of somebody's life and try and give advice over this forum.
Especially without the full picture, with
Right,
with
exactly.
just the information you give. We're trying to give you the generals to understand, what all these terms mean and that kind of thing. But again, we can't get into legal advice for
Right,
individuals.
exactly.
Okay, Caleb wants to know what would be the benefits of a Medicaid planning trust?
So I'm on thin ice with Medicaid planning because I don't do it. I know enough to be dangerous, but I can tell you that a Medicaid planning trust can allow for some of the assets to be preserved but it isn't like an irrevocable trust, and there's some issues about losing some control. And so it's one of those things that if somebody is really wanting to be able to go on Medicaid for their nursing home care, really their family needs to seek legal advice from a Medicaid planning attorney.
And I just want to remind everybody, we did a webinar on this on Tuesday of this week, and the recording of that webinar will be available this afternoon on our YouTube channel, if you want to look there.
That's great.
Okay, next. What do you do if an agent on one of your directives, such as medical POA, moves so that the address is no longer correct? Do you have to complete a new one?
The address in those documents is not critical. It doesn't make it invalid just because the address is wrong. It's there to help locate somebody, but it does not mean that you have to do a whole new document. They're still a valid, and they don't even have to be in the state to be, your medical agent or any of those things. They can even talk to doctors remotely, come in when they're needed, those kind of things. But changing an address is not, that alone is not a reason to change your document.
Okay, next. Where can you get a transfer on death deed form?
I have no idea.
I'm going to tell you, you can probably get one to the Texas State Legal Center, or Legal Aid of Northwest Texas, and I will have the links to both of those agencies in the follow-up email, and you're more than welcome to reach out. This Texas State Legal Center, I think is what it's called. Is that right? They would be the first one I would contact for that.
Okay. What is the best option to avoid taxes upon death? I have a revocable living trust.
So estate tax, what's interesting is where we sit right now, most people don't have to worry about an estate tax. The exemption amount this year is $13.99 million per person. If your estate is worth less than that, when you die, if you were to die this year, then there is no estate tax. Now, there may be taxes because you may have an IRA that the income taxes haven't been paid on. And so whoever at whatever time takes assets out of an IRA, they have to pay the income tax on it at their income tax rate. But that's not an estate tax, that's an income tax. And so it's not because it's inherited, it's because it's never had the income tax paid on it. Now, with that one big beautiful bill that was passed earlier this year, the estate tax exemption rules were made permanent. At the end of this year, they were supposed to sunset, and that estate tax exemption was going to get cut in half as of December 31st of this year. But that new law that passed earlier in the year, I think it was July 4th, that law did away with that sunset provision and made the law permanent. So next year, the estate tax exemption will be $15 million per person. And it goes up from there for inflation every year. If somebody has an estate worth more than $15 million, or a couple has an estate worth more than $30 million, there are tax planning and asset protection planning things that need to happen for someone with an estate that size, but they are way too complex and above my head. My partner Rex Hogue does that in our firm for me to go into here. But there are ways, when you have an estate that is over the exemption amount, there are ways to plan to avoid or at least minimize the estate taxes on your family.
Okay, what is the difference between a living trust and an he means revocable and irrevocable trust. That's what he means. He
Okay.
said, can you make changes on both?
Okay, so an irrevocable trust is just that. It is meant to never be changed. Now, I can't tell you that there are not any ways to change it, but they are difficult and expensive. A revocable trust is revocable, amendable. You can restate it. It's got all the flexibility, but it doesn't have, like, the irrevocable trust has its place. When I mentioned just now about asset protection and tax planning, a lot of times that's going to involve sometimes a number of irrevocable trusts for different reasons. And so there is a place for an irrevocable trust. But when you're just talking about generally just doing your estate plan to make sure that you're taken care of if you're incapacitated, and your family is taken care of when you're gone, that is generally going to be a revocable trust that is that you can change at any time as long as you are alive and able have the capacity to sign legal documents.
This is a good one. Does not having title insurance stop a real estate sale? Is it required in securing a bank loan?
So real estate law is not my area of expertise. I feel safe in saying that depends on the parties. You know, if the buyer doesn't insist on title insurance, I don't think that it is legally required. It's just that they are taking a chance. And if somebody comes up down the road saying, you know, I had interest in that property, then they're going to have a fight on their hands if they don't have insurance to cover that fight. Because that's really what title insurance is about. If somebody comes up, if you've got title insurance and somebody comes along and says, oh no, that's my property, then the title insurance company is there to fight for you. Just like if you're in a car accident and your auto insurance company steps in to fight for you. And so I don't know of anything that requires it, but I don't know very many people that would want to purchase property and not have title insurance.
Yes, when you don't have title insurance, it is going to severely affect your ability to sell it, because it's going to affect a title company from insuring the title later if there's a gap in the insurance period.
Correct.
And so it's a tough deal. I'm with you. I highly recommend you get title insurance.
Yeah.
Do you have to probate if you have a will and trust?
It depends on if all the assets are aligned with the trust. If they're aligned with the trust, then there's no need for probate. But if there is if there's one asset that is in the decedent's name only, with no beneficiaries, no co-owner, and not in the trust, then that asset's going to have to go through probate. Now, it won't involve all the assets. It would just be that asset. But it would have to go through probate to then get in the trust. The goal when we do trust planning is that there's not going to be a probate. My least favorite scenario is when a client comes in for trust administration and we have to do a probate on top of the trust administration. That is, I mean, while it brings in more fees, I don't like that because it's not what we intended in the planning. I'd much rather have the assets titled in the trust. So that, like I said, that will is there for that just in case, but we do our very best to educate our clients on how to get their assets aligned with the trust. And as long as they follow those instructions, there shouldn't be an issue.
What happens if you have a trust but no will and the person has died?
Well, if all the assets are in the trust, you're okay. But as I mentioned that story earlier, I've had that happen where none of the assets were in the trust. Then you have to do an intestate probate, and it's going to go where the law says it goes. In my situation, you know, a lot of the assets were joint with right of survivorship with the spouse, and so there was no probate necessary for those. But when it came to their home, we had to get the kids, her kids in here, signing deeds, gift deeds, and transferring their half to him. It was just a really big mess because we had to do an intestate probate, and then they were entitled to they were entitled to her half of any of the assets that were going through probate, and that does create a problem. It's not impossible, but it creates more expense and more mess.
I think this person has misunderstood something you said, so you got to clarify this. So do you recommend working with an attorney first to assist with the trust and will prior to consulting with an estate planner?
Okay, so you're probably confusing estate planner and financial advisor, if I had to guess. Because an estate planner should be an attorney. That's the person that's going to do your estate planning. But if you're talking about your financial advisor who is talking to you about all your assets and how they need to be handled, then you can do either or first. What I will tell you about really good financial advisors is one of the first questions they're going to ask you is, do you have an estate plan? Do you have a will? Do you have a living trust? They're going to ask you those questions. And if they ask you that, if they're handling your assets and everything's in your name and you don't have a plan, they're a good financial advisor is going to say you really need to talk to an estate planning attorney and get a good plan. But it doesn't mean you can't do some of that financial planning. What's going to happen once you do have that estate plan, if you do a trust, then your financial advisor is going to need to come along after that. And most financial advisors, good ones, know exactly what to do with a living trust and what to do with your assets to get them aligned with the trust. So you need both. What order you see them in is not really critical, but a good financial advisor is going to tell you, you know, we can do all this, but you've got to have an estate plan, and they might even give you good recommendations for planners. Some outfits have financial planning and estate planning all in one, and that's fine. But you definitely need the financial planner and the estate planner.
Okay. With a living trust that has a house in it and annuities, stocks, and etc. are EOD, do things like cars, jewelry, etc. go into a will? Then what do you do with the will?
Okay, so the way that personal property is handled, that's what you've just described, is we actually have a document, and I've seen it in other packages when I've administered somebody else's trust, called an assignment of personal property. And so that document is very broad. It covers all those non-titled assets like your jewelry and your furniture and your clothing and your artwork. Anything that doesn't have a title is covered by that document that assigns it to the trust. And so by that, it's in the trust. Cars are a little bit different because they could be titled in the trust. They have a title. We generally will tell our clients not to put their cars in the trust. And the reason that we're comfortable with that is because there is a way to transfer title to a car without going through probate. The Department of Motor Vehicles has something called an affidavit of heirship that the heirs can fill out. and transfer it wherever they want it to go after death. So they can sell it, or they can say, oh, we want, little Johnny to have the, grandpa's old car. And so they can transfer it to little Johnny. As long as all the heirs are in agreement with that, then it's very easy to transfer the title to a car. The reason we don't like them in the trust, I mean, first of all, it's a little bit of a pain. Cars are, you go through a lot of cars during your lifetime. And so every time getting it in the trust can be a little bit of a pain. But the real issue is it creates a psychological reaction. If you get in a car accident and the person you hit finds out that your car was in a trust, then there may be all of a sudden their neck hurts worse, or they're more seriously injured. It's just a psychological thing. And so we just tell our clients it's best, it doesn't put your assets at more risk as far as that goes. One thing I do want to say about your standard living trust, it does not give you asset protection. So if if you're worried about being sued, putting your assets in your standard living trust is not going to protect them. There are ways to protect your assets, but that is not one of them. A lot of people just have that myth in their head. Oh, I put it in a trust, it's protected from everything. No, that is not the case. And I have to say it a lot of times for clients to get it, because there's so much misinformation out there. Putting your car in the trust doesn't, if you get in a car accident, the assets in your revocable living trust are still at risk just as much as they were before you put them in the trust. And so it's not really an additional legal risk. It's just the psychology of it. People just see the word trust and they think, oh, you must be wealthy. And then they, find a way to get at your money. So that's why we give that advice.
Where can we obtain a HIPAA consent form?
Those are things that we provide in any package. Any attorney that's doing a full estate planning package will have those. There is probably a legislative form that you can get. Marty might have some direction on where to find that.
Again, the Texas State Legal Center, or if you're low income, through Legal Aid of Northwest Texas. And many of people on here I know aren't from the Dallas-Fort Worth area, but you should be able to first of all, the Texas State Legal Centers for anyone, but you should also have a legal aid organization that services the area where you live.
Okay. Can one spouse predetermine certain assets prior to the marriage to go to their children, or determine or another person other than the spouse?
I'm going to have to guess a little bit at what that question really means. If you own assets prior to marriage, then that's your separate property. And we have a lot of clients that will have a trust while they're single, and then they get married and they come in together and we figure out how to adjust their estate plan. Any assets that you own prior to marriage, you have the right, any separate property you own, you have the right to decide where it goes. If it's something that you own after you get married, then it's generally, in Texas, it's going to be community property. There's some exceptions, but for the most part, anything you earn or accumulate during your marriage is going to be community property. And you can only say where your half goes. And so you do have the right to even, redirect half of your community property if that's what you want to do. But you can only determine where your own assets go. You cannot make someone else send their assets a certain direction. I hope that answers the question.
Okay. When both grantors, and I think this means trust makers, have died, does the designated trustee have to get a new tax ID for the trust?
Yes. I mean, with maybe some exceptions, but once you get to that point where both trust makers or grantors, which is another appropriate word, both of them are gone, then the trust becomes irrevocable. And when it becomes irrevocable, you have to have a tax ID number for it. It's possible to direct the assets to the beneficiaries, skipping that step, but not usually, because if you've got any assets at all in the trust that need to be moved from that trust to beneficiaries, then whatever institutions you're working with, banks, financial institutions, is going to require that there's because they can no longer use the social security number of the person who's died. And so they're going to require a tax ID number for you to operate as trustee.
Okay, the same person says, for a simple estate, only bank or finance institutions, would it be just easier to put a POD designations on all of these accounts? And would this avoid probate?
So that will avoid probate as long as the beneficiaries listed are alive and well. That would avoid probate and guardianship. The problem is if you've just got those kind of accounts that are all POD and you become incapacitated, then you're going to have a guardianship while you're alive. That's why we talk about the estate plan needs to work while you're alive, not just for it's not just about where your stuff goes when you die. And so that POD does no good if you're incapacitated, because the people that you've made beneficiaries, and probably your kids, probably people that you would want to take care of you if you were incapacitated, cannot access it because you're still alive. And so it doesn't fix everything.
Would a spouse automatically receive all assets, or would it be best to get a trust to ensure this? You may have answered this question, but what is the difference between a living trust and irrevocable trust? And last question, for couples with minor children, would it be a good idea to include guardianship of those children in the trust if both parents pass away?
Yes. Okay, so the last question's easy to answer. Yes, if you've got young children, then you should have a plan for what if something happens to both of you, and that's a declaration of guardianship for your kids. A lot of times that is also included in the will, but that's not a great idea, because what if you don't need a probate, but the guardianship declaration is in the will? Then you have to probate the will to get to the declaration of guardian. So having a separate document's a good idea. The spouse is not going to, if you don't have a plan, the spouse is only going to automatically get what you own with them with right of survivorship. And then it's not, it's almost automatic. They have to provide a death certificate in order to get the deceased spouse's name off of accounts and things like that. But if you don't have a plan, and Sheila, read that first question again. Let me make sure I'm covering all of it.
Okay. All right, I gotta find it. Hold on. I'm still not there yet. Okay. Would a spouse automatically receive all assets, or would it be best to get a trust to ensure this?
Okay. Well, I know you can tell from just the whole talk that I'm biased and I think it's best to get a trust, but it's the joint with right of survivorship thing that can make it automatic. Where people run into trouble is with real estate, because it's very rare to have a deed that has that kind of language in it. And if it does, whether it's done correctly or not. In Texas, when a couple buys a home or any real estate, they own it as joint tenants, but not with right of survivorship. And so they own it 50-50. I have had countless times where the kids have come in after the second spouse died and said, Mom's died, and we know we need to probate the will because her house, we need to sell it and we need to get it out of her name. And Then I start asking some further questions. So when did mom buy the house? Oh, well, she and dad bought it back in the 70s. Where's dad? Well, he died in the 90s. Okay. Did someone do a probate when dad died? No, it just went to mom. Well, the reason they believe that is because the taxing authority, the tax assessor, knows not to bill dead people. And so they changed the bill, the tax bill, to go to just the surviving spouse. What is the only paperwork you get that has to do with your house or your real estate after the initial closing? Your tax bill. So you get the tax bill every year, it's just in your name, and you think that somebody has magically transferred your spouse's half to you because you don't understand how Texas law works. And especially if you've been in another state, every state is different on how they handle real estate. And some of them, there's an automatic, like they own it 100%, both of them own it 100%, and there's nothing to do. Texas is not like that. And so we end up with a double probate. And that first probate may be really old. And I told you wills have to be probated within 4 years. That creates a level of complication. So there's nothing, I would say, just kind of a blanket statement. There's nothing automatic about real estate transferring to the surviving spouse. There again might be some very few exceptions, but generally speaking, you're going to need to go through probate to get that to happen. If it's not in a trust. If it's in a trust, you don't have to worry about it.
Can we stop for just a minute and change the slide?
Yeah.
We're coming up on the end time, and I just need to go over the CEUs. If you're welcome to come back and answer more questions, but Susan, that's purely up to you and your schedule. But let me go through this if I could real quick. For those of you that are joining us today for CEUs, we're providing complimentary CEUs for licensed social workers and licensed professional counselors within the state of Texas. If you have a different license in Texas or a license outside of Texas, you are more than welcome to go through the process, get a certificate, submit it to your jurisdiction, but please note there's no guarantee they'll take them. I've had people tell me that they've taken them, they've been able to use them, and I've also had jurisdictions reach out to me for more information on a webinar we've done, so they can determine if it's acceptable for their standards. The certificates, we're also providing certificates of attendance. Like again, they're all complimentary. It's good for 1.5 hour CEU credits. In order to qualify, you must have completed the entire live webinar and the Q&A up to 3 minutes ago, which was our advertised end time. You must complete also the Google evaluation survey. It should pop up as you close out of Zoom today. It should ask you if you would like to take a short survey. But if you don't have it pop up, some companies have pop-up blockers. No worries, you will get a follow-up email from me tomorrow that will have that information in it. You have a week to complete that, and then give us about 4 weeks after that point to get the certificates to you. I will tell you right now, I'm running behind because of some personal stuff that I've had to take care of, but we do get caught up. You will get it sooner or later as long as you qualify for it. So Susan, it's if you'll back up a slide, there you go. I want that slide up. And so it's totally, I don't know what your time constraints are. If you would like to wrap it up, we can wrap it up. If you would like to answer more questions, that is purely up to you.
Sheila, how did we do on the questions?
Well, there's still quite a few more.
There's a lot.
And some of them are simple. So, but
let's give it another 10 minutes. Let's give it another 10 minutes, and then and of course anybody that needs to drop off. But yeah, let's give it another 10 minutes.
Okay, the next person.
Thank you. First of all, thank you very much for doing that. That's very generous.
Of course.
Go ahead.
Absolutely.
Next person has 2 questions, so I'm going to do them together. Will a will and trust, so trust with a will, avoid the complications of the blended family scenario?
Okay, is that I thought you had two questions.
There is another one. She also
Okay, all
wants to
right.
know, is a living will the same as a will? No, it isn't, but I'm gonna
no.
let you answer.
Okay, so a living trust absolutely can avoid the problems of a blended family, or at least, again, can't do anything about personalities, but at least make it better because it's got a lot of flexibility to be able to protect everybody and make sure everybody feels comfortable. So yes, the blended trust is a very good option for a blended family. And then no, a living will is it's another word, another phrase used for your directive to physicians. That's the document where you say what you want with regard to life support at end of life. And I want to take that opportunity to distinguish between directive to physicians and a DNR. They are not the same document. A lot of people think they are. DNR stands for do not resuscitate. The directive to physicians says after you've tried to resuscitate me and do everything you can to save my life, this is how I want to be treated. Keep me on life support, take me off life support. That's the decision there. A DNR says if my heart stops, do not do anything to start it again. And so they're very, very different documents. DNRs are generally prepared or offered by healthcare workers, healthcare entities like your doctor or a hospice, very common with hospice. We do not prepare DNRs. So they're very different documents. And my opinion, it's an opinion, not legal advice, but my opinion is if you're up and walking around and have any quality of life, you don't want a DNR. Because that basically just says don't touch me. So you want to be really careful about that.
Okay. If you owned your home prior to marriage, this is similar to a question you had before. Is it safe to go to your children? Then when we own a home together, that's different.
So if you own a home prior to marriage, you can leave it to your children, but there is a statutory requirement that has nothing to do. You cannot undo this statutory requirement. Every surviving spouse has the right to remain in the home that they live in when their spouse dies. So let me give you a perfect example. My aunt married a man and moved into his home, and then he died before she did. She had the statutory right to live in that home the rest of her life. She had some obligations, had to pay certain, had to keep the house up, those kind of things. So you have to be able to do that. But she had the right to live there, even though his will, and he never redid his will left everything to his brother. So his brother was the owner, but my aunt had what we call a statutory life estate, and she lived there until the day she died. Now, the day she died, we made sure his brother knew it, and very quickly he came in from out of state, and we got all her stuff out, and he sold the house, but he could not do anything with it. Neither, if her husband had children, they couldn't force her to leave. And so that's how that works. Whatever home, no matter who owns it, whatever home that they lived in when the first spouse dies, the surviving spouse has a right to live there. They don't have a right to sell it. They don't have that kind of right, but they have the right to live there. If they abandon it, then it can go on to the heirs.
This is the perfect question for Susan. Upon death of a person with a living trust, what steps does the trustee need to do to activate the trust?
Short answer, call an attorney that does trust administration. Best to call the attorney that created it and find out if they do trust administration, because they're going to know the most about what's in that trust, and it will be less expensive with them than it would be somebody that isn't familiar with the trust. But that's really the short answer, because there's a lot to do. But if that successor trustee will call a lawyer, and it is important that they ask, do you do trust administration? There's a lot of law firms out there that create trust but don't administer them. We get direct referrals from attorneys who will send things our way because we do trust administration, and they'll tell their client, no, we don't do it, but we know somebody who does. But that's the first question to ask whoever you're calling, and make sure you've got somebody that does trust administration, because it is a complex undertaking that an attorney with experience needs to help with. And not every case is complex, but you need an attorney that knows what they're doing to evaluate that and determine what needs to be done.
Okay, this one, okay. I have an adult son with special needs and he receives SSI. He will not inherit enough to replace the SSI, and he would not be able to manage a large amount of money. What is a special needs trust, and would that protect him?
So anyone who has a special needs person in their life should have either a special needs trust while they're alive, if there's the desire to transfer assets to that person while they're still living, or their trust should have features in it that equate to a special needs trust for that person when they pass. So either one of those options is a possibility and should be done, because any amount of an inheritance can remove government benefits depending on the circumstances. And you don't want someone to lose. It's one thing to lose money, but if you've got money to replace it with, maybe not a big deal. But those government benefits are not always just financial, and yet they might depend on financial qualification. And so if someone who is on, medical government benefits or some sort of support that is not financial, then they could lose those benefits, which could be really critical to their health. They could lose those benefits if they get an influx of cash, basically. So if you've got someone in your life, and I will tell you that a good trust will have that backup provision, even a good will have that backup provision in it, that if there is anyone that is special needs on government benefits, that they are not to receive those assets outright. They are to sit in a trust for that person so that they don't lose their government benefits. But you need some sort of a plan that will do that. And most of the time with our clients, even when they have like a special needs child, they're not really looking to give them anything right now. They just want to make sure when they die, they're not harming their beneficiary. And so that can be handled within their estate plan.
You know what? You guys have given us very generously given us another 10 minutes. And so I'm going to just say from here, if you guys have any more questions or any questions we didn't get to, you're more than welcome to email me them. I'll be happy to pass them on to Sheila. But I know Sheila and Susan both have other obligations as well. And we're really grateful for you even offering the time to do the webinar today. Thank you so very much. Thank you all so very much. Hope that
it's been helpful. It was nice to get to visit with you guys, and give us a call if we can do anything for you.
Great. Sheila, thank you so much for all your work and getting it organized and everything. I certainly am grateful to both of you.
Thank you, Marty.
Thank you all for joining us. Look forward to the follow-up email and information about future webinars. And I'll include the link to the video for the webinar we did on Medicaid planning when I send out the follow-up email. Y'all have a wonderful day.
Thanks, Marty.